Hello, everyone. It's Rob Ryder. Uh, Today we're going to talk about Samuel G., who was tried in a venue beyond the sea. Sam's an Amish man, just got 68 years federal prison, allegedly, for pissing off the FDA. And this goes all the way back to the time of the Declaration of Independence, because the colonists complained at the time that King George III was transporting us beyond the seas to be tried for pretend offenses in English criminal venue law, or as part of English criminal venue law. And in the Declaration of Independence, it does say, he has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation for transporting us beyond the seas to be tried for pretend offenses. Well, it appears that the king obliged his subjects, and so he brought his courts across the sea for his still loyal subjects to try the likes of you and me, unless you challenge the venue. And so while we're going to use Sam's case and a bunch of other pieces of paper to look at to say, well, this is what, this is where the mistake is in their paper. It all comes down to this. They're charging us in a foreign venue. And you can challenge venue. All you need to do to challenge venue is say that you challenge venue. You challenge its improper venue. You don't have to give them a reason. Once you charge as the defendant that this is an improper venue, the plaintiff attorney has to prove that it is the proper venue. So more about that as we go. But my email address is courtofrecord@aol.com. That's for Rob Ryder. Of course, that's my avatar. And my phone number is 616-712-6179. And if you can, I really do need you to donate. That would be by PayPal to ashleyrytluski@gmail.com, ASHLEYRYTLEWSKI@gmail.com, by Western Union or Walmart to Greenville, Michigan. That's the closest locations. Or by mail to Robert Rytluski. That's RYTLEWSKI, 10955 14 Mile Road, Rockford, Michigan, MI 49341. And that MI will be very important, because MI means I'm in Michigan. I'm not in the state of Michigan. I'm just in Michigan, which is the free and independent state that was created under the Constitution of 1835, in which it says the style shall be, words to that effect, the state of Michigan. So unless the is part of the name, then its nickname is Michigan. But state of Michigan by itself is not the state of Michigan, nor is it Michigan. It's a private society that happens to have its headquarters in the state of Michigan. And it uses the boundaries of Michigan, but it isn't Michigan. More on that as we go. So if you did nothing else, and you had to go in today because you have a court case going on of any kind, I would put something to this effect in as a motion, aka a petition. I, your full legal name, mine's Robert Allen, Allen, Rytluski, petition the court, ex parte, because I don't need anybody's permission, to issue an order dismissing this matter due to the plaintiff's attorney of record prosecuting in an improper venue, and award me reasonable attorney fees and other equitable relief the court deems just, be it judicial foreclosure, taxes, debt, criminal matters. Right? Prosecuting in an improper venue is a violation of Article 3 of the Constitution of the United States. And we're going to see where all that comes from. And once you, as the defendant, once you challenge venue, the prosecutor has to prove he's in the right venue. Well, if the prosecutor is prosecuting the crime in a wrong venue, then he's using his office for private gain. That would be misconduct, right? So we're talking contempt of court for any attorney at law licensed to practice in Michigan, Wisconsin, name your state, to bring a matter into a foreign jurisdiction, knowing that it's a foreign jurisdiction, um, and doing so, not doing it as an attorney because they never use their proper name. This is why they're never using their proper name. They don't use their proper name on paper. They always use the name with the middle initial because they drug you into this foreign venue. And so we're always told to, you should argue jurisdiction, which is true, but it's the venue because they have different words. Venue and jurisdiction have different definitions. And if you're taken into a particular venue, then its jurisdiction is the jurisdiction. And if you haven't said, well, this is the wrong venue, then you've already agreed to the jurisdiction. So, arguing jurisdiction at that point doesn't make any sense. It's too late. The very first thing they did is got you to go to the wrong venue. And once you're in the wrong venue, it won't matter what you do, you'll always be wrong. And it's that simple. That's how this whole system would work. If it's based on one beginning lie, then the beginning lie is they put you in the wrong venue. So let's look at some things. First, let's just read a little bit about what this is about venue. So in Wikipedia, under venue, you got like 4 or 5 different choices. You pick the law one, you'd be reading things of this nature. The perceived abuse of English criminal venue law was one of the enumerated grievances in the United States Declaration of Independence, which accused George III of the United Kingdom of transporting us beyond the sea to be tried for pretend offenses. Article 3 of the United States Constitution provides that trials of all crimes shall be heard in the state where the crime shall have been committed. But when not committed in any state, the trial shall be at place or places as Congress may by law have directed. Well, if you have a driver's license and you look at your driver's license, mine just says Michigan on it. Doesn't say state of Michigan, right? So my state is Michigan. That's where I'm a resident of. And so as the defendant, they need to bring the charge into my jurisdiction. And they're not doing that. The locus delicti must be determined from the nature of the crime alleged and the location of the act or acts constituting it. Thus, venue may be constitutionally permissible even if an individual defendant has never personally present in the relevant state. For example, conspiracy may be prosecuted whenever the agreement occurred or wherever any overt act was committed. But what's the nature of the crime, right? If they're going to charge you with a statute violation of the Michigan compiled law, then they need to try it in Michigan. They can't try it in the state of Michigan. That's not a law of the state of Michigan. It's a law of Michigan. It's in the Michigan compiled laws, not in the state of Michigan compiled laws. Well, when they take you to court, at the top of the paper, they'll say state of Michigan. Well, they took you into the wrong damn jurisdiction. And so they're not going to really be charging you for the MCL that they write on the paper. They're going to be charging you for the words they wrote next to it. More like an English common law where, things had names like trespass or against the peace and dignity of the state, right? That would be disturbing the peace. Those are common law crimes. And that would be being tried in the king's courts. So, for the purposes of constitution of venue, the boundaries of the state are questions of law to be determined by the judge, but the location of the crime is a question of fact to be determined by the jury. Meaning, first of all, the judge has to determine if it's the proper venue, if you bring it up. And he's going to do that by the boundaries of the state. So, we go to the origins of the nation, and when they were doing the public land survey, they went from after the 13 colonies west and started doing everything by township, range, yada, yada, yada. Well, that is the Public Land Survey legal description of the land. And that is what was ceded by the federal government to the state to become a free and independent state. That style of coordinates. And so if the state is using a different style of coordinates than those, then it's not the state that was created from the land given to the state by the federal government. Because that was all done by Public Land Survey. And they use different styles of coordinates. I mean, if you were to look at your tax bill, that's a different style of coordinates than the land survey, but that's what they want you to pay the tax on. Well, what is that? Right? It's got nothing to do with a land survey. It's not the legal description of the land that you're supposed to own. And so, really, if you look at your tax bill, you'll see that acreage is 0.0. Right? They're not charging you for any land. Well, then what's the taxes for? I thought it was supposed to be taxes on it's on your property. Oh. Well, more on that later, but because your property, you're the tenant when you look at your paperwork for what you believe to be the home that you own. Well, you're just the tenant, and you don't have a certificate of occupancy, and somebody else owns it, and you're paying rent, and all this tax that you pay is just a form of rent to the real owner because they never really transferred the property to you. And sure, it's a crime, but we have the same problem when we go to court. If we don't bring the action in the proper venue, then we're not going to win. And so these things need to be stated in the actual court case. So I'm not really sure yet on how to do it prosecuting, but defending, it's really simple. You just file a motion or a petition saying that you asking for dismissal based on improper venue, and then ask for relief, right? So I mean, that's what I'd be doing. That's why I kind of wrote it the way I did, and just real quick take a look at it again because you may want to do this. I, your full legal name, petition the court to issue an order dismissing this matter due to the plaintiff's attorney of record prosecuting in an improper venue, and award me reasonable attorney fees and other equitable relief the court deems just. And so that's what Samuel G. needs to do, and I'm going to talk to the people that know Samuel G. that told me about Samuel G.'s problem and see if we can get somebody to file a motion. I've already written to his attorney of record to say, hey, brother, why'd you let this happen? I think I did that yesterday. So, but we need to bring more forces to bear than just one dude sitting in a house in Michigan who really can't afford anything. So one of the things I need to do is donate so I can do a little bit more. Until then, I'll do what I can, and that's to point out the things I see by reading what they had to say. So what's this locus delicti? And then we'll get back to Wikipedia. Is a Latin term which means the scene of the crime. It is a place where tort, offense, or injury was committed, or the place where the last event necessary to make the act reliable occurred. In the case of a civil proceeding, it is the place where the alleged thing was done. For example, the place where disputed property lies. So does your property lie in Kent County or County of Kent? Wherever you are, they're using the same system, right? Blank County or County of blank. Only one of those is the proper state political subdivision. The other one is something that's trying to act like the proper state political subdivision, but it isn't. It's a foreign venue. And their locus delicti, if you go there, they're using different laws. The locus delicti gives the court exclusive jurisdiction over the dispute or crime. Under common law, crimes are local, and it is cognizable and punishable exclusively in the country where it is committed. So was it committed in Michigan, proper case, or state of Michigan, uppercase? Well, I'm going to say it was in Michigan. I'm not going to say it was anywhere. I'm just going to say they brought it in the wrong venue and make them prove it because that's their job. The locus delicti, commissii, is a Latin term for law of the place where the delicit tort was committed. In the conflict of laws is a branch of law regulating all lawsuits involving a foreign law element where a difference in result will occur depending on which law was applied. So for the same set of facts, one's going to find you guilty, the other one's going to find you innocent. Well, they've taken you to the one that's going to find you guilty. You want to get out of there, you need to get to the one that will find you innocent based on the same facts. It's really that simple. You must challenge the venue first. It's the very first thing they did wrong. Right after that, if you're already in that stream where you haven't challenged venue, then everything they're doing is okay in their system of law. You just happen to think you're in the proper system of law, and you're not. You're in the Talmudic court. The term is often shortened to lex loci delicti. When a case comes before a court, the parties and the causes of the action are local. The court will apply the lex fore, the prevailing municipal law, to decide the case. However, if there are foreign elements to the case, the forum court may be obliged under the conflict of law to consider the following issues. So even though they've taken you to this forum court that's hearing it in a foreign law, if you point out it's the wrong venue, they're obliged under the conflict of laws to consider the following issues. It adjudicates whether the forum court has jurisdiction to hear the cause. And it subsequently applies the choice of law rules to decide the lex cause, that is, which law is to be applied to each cause of action. And so basically what the prosecutors are doing, or these attorneys in foreclosures or whatever, they're forum shopping and taking us to the forum that if we agree to the forum because we didn't challenge the venue, they're going to win because they got license and we don't. Okay. That was the locus delicti, nature of the crime. The venue may be constitutionally permissible even if an individual defendant was never personally present in a relevant state. However, it isn't constitutionally permissible because the Constitution says shall be held in the state where the said crime shall have been committed, and they're taking you out of the state and into a foreign jurisdiction. Civil venue. Venue is either a county, that's if you're in a state court, or a district or division if you're in a federal court. So if you're in your state and they take it to the federal court, well, you're not being tried in your state. And the Constitution said you need to be tried in your state. Article 3 of the Constitution. Where are you? Shall be held in the state where the crimes shall have been permitted. But when not committed within any state, the trial shall be at places as the Congress may by law have directed. However, because you're the defendant, they have to try it in your state. And they're not doing that. Okay. May be filed or commenced. It involves a decision in which district, federal court, or county state court is appropriate based on typically on where the matter occurred or where the defendant resides. Now, they did create a federal court. So like in Michigan, when they were creating Michigan, they passed an act, 5 stat something, in which Michigan was considered a district. This was to enforce the laws of the United States. So Michigan was considered a district, right? It's the District of Michigan. And that court has a proper name, but that court name isn't the name that they use in the federal courts when they're prosecuting you. It's a lot easier to show you the examples. Venue under American law is a concept distinct from jurisdiction, which focuses on the authority of a court to hear a particular case. Venue is concerned with the geographical location of the court where the lawsuit commenced. However, unlike personal jurisdiction, there is no constitutional requirement for proper venue in order to have a valid judgment. And so they can try you in this other court if you've agreed to the jurisdiction. This is their perception now. I didn't say it. But if you have, and they find against you, well, then it's a foreign judgment that you'll just enter into the proper venue. Say, we got this judgment over here. Please enforce it. Defendants can waive venue at time of trial. Plaintiffs may also waive their right to sue in certain venues through a contract that contains a valid reasonable forum selection clause or venue selection clause. Well, that would be the Constitution. It's got a valid one. You need to try the defendant in his state. And they have you going to the same frickin' foreign court that they're taking you to when you try to be the prosecutor or to prosecute your own case. Okay, so the proper recourse for challenging venue is a motion to dismiss for improper venue. That would be in the Federal Rules of Civil Procedure 12. This is one of the waivable defenses, meaning that it must be made in the initial response to the complaint or it will be waived. Doesn't mean you can't bring it back. It's just been waived. Well, I guess you don't care. You can come back later and say, hey, I do care. You know what? Because I have the constitutional protected right to be tried in my state. And I say this was done by deception. But you don't have to say that. You just need to say that you're challenging frickin' the venue. Right? Rule 12, defenses and objections. When and how to present it. How to present a defense. Every defense to a claim for relief in any pleading must be asserted in response of pleading if one is required. But a party may assert the following defenses by motion. Motion asserting any of these pleadings, defenses must be made before pleading if a responsive pleading is allowed. If a pleading sets out the claim for relief, does not require responsive pleading, an opposing party may assert at trial any defense to that claim. All right, so this is just do it before the trial. You can do it at the trial. You can do it in open court. I motion the court to dismiss this matter because the plaintiff's attorney has brought this in an improper venue. It's something to remember when they say judicial district. Now, this is what it says in Michigan's laws, right? Means this with regard to the circuit court, that would be the county. With regard to municipal court, city and municipal court functions, or village. With regard to a district court, the county, the district, or political subdivision in which venue is proper for criminal actions. Well, that's the one we're really looking for, right? Because if we want to take somebody to court, it's because they committed a crime. I'm not taking my brother to court to argue over land. I'm going to take my brother to court if he's committing a crime and trying to take my land, right? Or a public officer won't do what I need him to do, what the law says he's supposed to do. Well, I need to know what the proper venue is in Michigan for criminal actions. And then there's another clause in the Constitution that talks about the vicinage clause. Sixth Amendment of the Constitution regulating the vicinity from the jury pool. The clause says that the accused shall be entitled to a jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. You can see how important that is, right? If you agree to King George's jurisdiction, then King George's people are going to be the jury. I believe you're going to lose. If you say, well, that isn't my jurisdiction, or that isn't my venue, then the jury has to come from the state where you're from. Well, that would be the jury of your peers. And so you can have a jury of your peers. You just have to be in the right venue. But you don't have to say you want to change the venue. That's the thing. Don't change the venue. Ask for a dismissal because they brought it in the wrong venue. Okay, let's get on to some examples here. What I'm talking. Let's go look at Sam's case. Okay. So this was the indictment for Sam's case. United States District Court, Eastern District of Kentucky, Central Division, Lexington. All right, so it's in a district, in a division, federal court. That's what they're trying to tell you. United States of America versus Samuel A. Girod. Well, right off the bat, United States of America is not the government of the Confederation of States created under the Articles of Confederation. That's right here. Articles of Confederation. All right, that isn't really the proper name, but you can go find it. It'll say the same thing. The style of this confederacy shall be the United States of America. That's the Republic. British American diplomacy, the Paris Peace Treaty of 1783, where it says that King George III, by the grace of God, King of Great Britain, France, Ireland, Defender of the Faith, Duke of Brunswick and Luxembourg, Arch Treasurer and Prince Elector of the Holy Roman Empire, and of the United States of America. United States of America. He's over the United States of America. He's not over the United States of America. He's over United States of America. He's over these people. Right? This is the wrong venue. You're in the venue of King George III. Stop right there. Appeal. The grand jury charges that Samuel A. Girod, and of course Samuel A. Girod is not this man's full legal name, right? So they're charging a legal fiction, a John Doe, in the United States of America, which is a legal fiction, is charging another legal fiction. Operated an establishment at 409 Satterfield Lane, Owensville, Kentucky, which is in Bath County and Eastern District of Kentucky. And that's where they lied, because Bath County is not in the Eastern District of Kentucky. Bath County is in Kentucky. It's in the state of Kentucky. And so Sam should have been tried in his jurisdiction, in his venue, Bath County, Kentucky. Not in some court in a district called the Eastern District of Kentucky. And so that there really isn't any reason to go any further. You could go read all the shit that he did wrong, and all the stuff's online. You can go look it up right now. Just put in Samuel A. Girod, and you'll find the site that has the paperwork to look at. My point is, right, Bath County is not in Eastern District of Kentucky. It's in Kentucky. It's in the state of Kentucky. And so by the Constitution, Sam was supposed to be tried in Bath County, Kentucky. Except the plaintiff, United States of America, attorney, somebody pretending to be a United States attorney, U.S. attorney is what they put down, brought it in a wrong venue, violating Sam's constitutionally protected rights. Carrie B. Harvey, United States attorney. Well, there is no Carrie B. Harvey anywhere that's an attorney. They can't use a frickin' middle initial on their paperwork to get the court order to be authorized to practice in the state. Because even federal attorneys practicing in the federal courts had to be authorized by the state to practice in the state court. They got to be authorized by the Supreme Court to practice in the state. Okay, so United States of America is not the government. Samuel A. Girod is not the man's full legal name, and he is not in Bath County in the Eastern District of Kentucky. He's in Bath County, Kentucky, and so he was charged in an improper venue and now is sitting in prison for being charged in an improper venue by somebody who doesn't have the authority to enforce the laws of the United States. Yeah, go figure. Now let's look at some of the, what else was there I just wanted to show. All right, so here's the case number. If somebody wanted to look, if you have Pacer, you can look it up. Because on this site, I got this, not all the Pacer documents are there, but this is supposed to be a criminal minutes, right? This is a clerk's entry. Should be. But for this case, and what they did, right here, defendant states true name is as stated in the indictment. Well, they never used Samuel's full legal name, but they're saying that he stated it's the true name. Now, that was with his counsel for defendant present, a man who was supposed to be licensed by the state of Kentucky to practice in Kentucky, who just violated his, as an officer of the court, just violated his frickin' office by allowing the defendant to state his true name is on the indictment, because it isn't his true name. But this is a minute order, and they're using this as evidence. Well, hey, he agreed, right? And it even has a seal on it, signed by some United States magistrate judge. Well, the only problem with that will be, if this is truly the proper seal, well, only the clerk of the court is the keeper of the seal. So unless this guy here is the clerk of the court, which I don't believe he is, he just said he's the magistrate judge, then this should have been attested by some clerk. And it isn't. So I don't know what to make of that part, but that's what it is. Docket. I should have pointed out they're using different court numbers, case numbers on this too. When you look at these things really close, like if we looked at where's that? We got this case number here, which isn't the same as this one here. All right, this is 515 CR 87 DCR. This is 515 CR, a bunch of zeros, DCR dash REW. They're not the same. This is 15 CR 87 DCR REW. Right? If you're going to put the zeros in, then there's zeros that need to be there. Those are placeholders. Because now 87, without those errors, actually up here it's 87, not with all the zeros. It would be 87,0000. Because they moved into the first positions instead of the last. USA versus Samuel A. Girod. Well, USA is not the United States of America. It may be able to say United States, because I believe the United States is the government of the United States of America. But USA is not the government of the United States of America. And for this to be the proper name of the court, it should say the United States District Court for the Eastern District of Kentucky. They're not using the full name. So look at this one, United States District Court, Eastern District of Kentucky. What's this one say? United States District Court, Eastern District of Kentucky, Central Division, Lexington, right? So this is in a different court than the other one. Filed in the Eastern District of Kentucky. It didn't say it's the United States Court. It says the Clerk U.S. District Court, right? Not filed in the United States District Court, filed with the Clerk U.S. District Court. And they're different. They don't have any problem writing words. I mean, we got bazillions of words, so it isn't a matter of space or words. It's a matter of defining different terms. Anyways, what I wrote based on that, because I was able to figure out who his who Sam's attorney was, Michael B. Fox, Fox Law Office. So if you're in Kentucky, pay attention. You may want to write this guy, give him a call, and say, hey, what are you going to do to help Sam? Right? We need to appeal a case because he was tried in the wrong venue. Michael B. Fox, Fox Law Office, 185 Tom T. Hall Boulevard, P.O. Box 1450, Oliveville, Kentucky, 41164-1450, 606-286-5351. May 30th. Improper venue, case 515 CR 00087-DCR-REW, and others by reference. Counselor Fox, you allowed your client, Samuel Girod, to be tried as a legal fiction, John Doe, instead of in his true name in an improper venue, by a plaintiff with no legal standing, resulting in a son of God's unlawful incarceration. Samuel's protections under Article 3 of the Constitution of the United States have been violated, where it says trial of all crimes except in cases of impeachment shall be by jury, and such trial shall be held in the state where the said crime shall have been committed. This violation could be construed as a misprision of treason. Right? You're letting somebody be tried for a criminal activity outside of his jurisdiction. In the holy name of Jesus Christ of Nazareth, I order you to file an ex parte petition motioning the court to dismiss plaintiff's case for improper venue in accordance with Federal Rule of Civil Procedure 12b3, and or the court to order Samuel Girod be released from his unlawful confinement, his immediate return to his residence, his property returned to him with compensation for damages, and any other relief the court determines just. For an officer or court not to do so could be construed as treason. Yeah, I'm calling him out, dude. You're committing treason. Unless you get Sam out of jail, your ass is committing treason, Michael B. Fox. And I'll try to get you prosecuted for it. So says the United States of America, ex-rel, Robert Allen Bertluski, 10955, 14 Mile Road, Northeast. County of Kent, Michigan, lowercase county, not proper. See, proper case County of Kent is the name of something. It's a proper name of something. But the county, the physical landmass with the boundary, is just lowercase County of Kent. Its political subdivision is called Kent County with the C capitalized. But if we were just to be talking about the physical landmass, then it's lowercase County of Kent. So, Michael B. Fox, right? If you're in Kentucky, if you're one of the people that may have been told to come here because you know about this case and you want to do something down in Kentucky, this is the man that knows what needs to be done. Whether he'll do it or not, I don't know. But if he won't, his ass should be impeached because he's an officer of the state. And now you need to get a hold of your state representatives who also didn't take the proper oath, but I don't know that they're nearly as corrupt as attorneys are. And they could be recalled. They could be taken out, whatever it needs to do to get them to file the impeachment papers against Michael B. Fox as an officer of the state, because he's a notary, and he's also an officer of the court. He's always considered in court. So anything he does that's against the peace and dignity of the state is a crime. Okay. Well, hey, I don't know what else to say, right? There's an example. We'll look at a few other ones, but that was the idea is, these guys aren't doing it right. What do we do? Group I. But because we can, we're going to look at just a couple of other. These are different cases that people have sent to me over time that I'm doing things with, and someone's different from different venue than complaint. Okay, so that's what I said here. So in this one, this is a credit card issue, Wells Fargo versus somebody, not using her full legal name. Wells Fargo Bank NA. I don't believe that they have a license to do business in Illinois. But anyways, this is the summons. And in the circuit court, of Cook County, Illinois, 6th Municipal District is where the summons is for. We'll get back to the summons in a second. But if you go to the complaint's in the Circuit Court of Cook County, Illinois. Right? So the summons and the complaint are in different venues. Also, the summons was not sealed under the court seal of the court. And I should show you where it says that that needs to be. So what I'm going to do here is just pause for a second. Okay, so is this thing recording? Record. Hello. Yeah, you're recording. Okay, sorry about that. Michigan court rules. Again, doesn't say state of Michigan. Michigan court rules, civil procedure. So every state has some kind of civil procedure rules, and it says how the paperwork's supposed to be done. And well, we're going to go down here and just really quick look at the part where it talks about the summons. Here we go. General rules. Hang on a second. Sorry. Okay. Summons. Issuance. On filing of a complaint, the clerk shall issue a summons. That was simple enough. Form. A summons must be issued in the name of the people of the state of Michigan under the seal of the court that issued it. All right, so all that to say, well, okay, it says it needs to be under the seal, and so if you get something mailed to you, I'm having a problem with my buttons today. One more time, hang on. So if you get a summons mailed to you and it doesn't say, you have to go check your state now, and it doesn't have a seal on it, and it doesn't say the magic words, all right, in the name of the people of the state of Michigan. You know what that is when they do that? That's a subpoena, right? Because only the court can call you to court. You can't be called to court in Michigan by a private individual. But in King George's jurisdiction, hiding in Michigan, apparently you can. Right? That foreign jurisdiction. Right there. So that's one example, right? This summons isn't sealed. Now, this is for Illinois, so I don't know if it needs to say in the name of the people of Illinois or not, but it would say in the rules for summonses what it needs to say. What I can tell you in Michigan is it says it needs to have a seal. It needs to say in the name of the people of the state of Michigan on it. And this one is for the 6th Municipal District, which is different than the name that's on the complaint. And so all you can do at this point is say, hey, they brought it petition for improper venue. Here's a gal out in Colorado where they're saying the name of the court is District Court, Arapahoe County, Colorado. Well, that isn't the name of the freaking court. Now, they have her name, I guess, properly done. Complaint and information, where it says George H. Bouchler, District Attorney for the 18th Judicial District of the state of Colorado, in the name and by the authority of the people of the state of Colorado, informs the court of the following offenses committed and triable in the county of Arapahoe. But that isn't where the defendant's from. She's from Arapahoe County. And so she was taken out of her state and taken into this state. Because this isn't the name of a state court in Colorado. It's some district. It's got a number. 3rd district, whatever it is, blah, 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 state of Colorado. Whatever the proper name is. And so, you know, we don't have to get too nitpicky. We just put in a motion to whatever it is and say it's the wrong frickin' venue. You can do it in open court. You don't even need to write it. If they got you in court, just tell them. On filing a complaint, shall issue the summons, right, in the name of the people of the state of Michigan under the seal of the court that issued it. Pretty freaking cut and dried for Michigan. Okay, I'm going to get rid of that now. One last thing to try to keep track of. What other ones did I have? What about Jeff? What's going on with Jeff? Jeff, right? State of Michigan, County of St. Clair. Wrong venue. Doesn't matter what they say you did, it's the wrong venue. Right? City of Port Huron, that's not the name of the city. I bet you if you go look in their charter, that isn't the name of the city. Although it could be, because it says St. Clair, so maybe that's proper, but that doesn't matter. They're saying that this happened in state of Michigan, County of St. Clair. Well, that's not where the defendant's from. Right? If it happened anywhere, it's in St. Clair County, Michigan. There's no victim or complainant. Right? The complaining witness is Det Dean. Bean. I believe that was probably for Detective Bean, but that isn't what it says. It says DET Bean. Well, who the hell is that? If we went down and looked at the last page of the information, it hasn't been authorized by anybody. It's not been signed by anybody. There's no clerks put on it, but they're using this to take a guy to court. Well, I believe if this is the way they do it, it must be an improper venue because that isn't quite the way it says to do it in the Michigan compiled laws or in the Michigan court rules or in Michigan this or that, in the Michigan Penal Code. It's wrong. Another one. Okay, clockwise, where District Court, City and County of Denver, Colorado. Well, that's like the second District Court or something like that, but it certainly isn't the District Court, City and County of Denver, Colorado. That's not the proper name of the court. And these people with first name and a middle, or no middle name, last name, well, that isn't their full legal name. And Cynthia H. Kaufman is not the name of any Attorney General, and Robert S. Shapiro is not the name of any Attorney General licensed to practice in Colorado. And yet, here we are. Denver District Court, right? So here's the District Court, City and County of Denver, and now they're saying it's the Denver District Court. Authority of the people of the state of Colorado upon their oath, present the following. Right, their own level of deceit, but it isn't in the court isn't using the name of the state court, so it's a different venue. So you need to what? Motion, petition for dismissal because the plaintiffs, people of the state of Colorado, attorney Cynthia H. Kaufman, Robert S. Shapiro, brought this action into an improper venue. Now, Cynthia with the full middle name, Kaufman, and Robert with the full middle name, Shapiro, are attorneys at law authorized to practice in Colorado who are using their office to bring a criminal matter into an improper venue for financial gain. Hang on a minute. Okay, sorry about that. Had UPS show up, and 2 minutes later, the postman showed up. All right, so where was I? Okay, I wanted to point out something. Look at this case number, okay? Case number GJ, case number 16CR001. Now, if we go and look at, what else did I have for that? The warrant for one of these. That's 2016 CR001. All right, 16 CR001. What's going on there? Oh, come on. Open it up again. Yeah. There we go. So on the, it looks like they're using the same name, but on these warrants, they use people's full names, first, middle, last, where on the indictment, they were just using first and last. Arrest warrant, the people state of Colorado, any peace officer authorized to execute arrest warrants, the Attorney General for the state of Colorado on this day, return an indictment charging somebody their full name, date of birth. Interestingly, it had a place for social security number and they didn't put it, right? Because they use your social security number as a form of identification. And technically, your social security number isn't in your full legal name, first, middle, last. It's in your name with a middle initial, right? If you had the stub that went to your social security card itself may have your full name on it in uppercase, and it is your property and you want to claim it. But the records in social security are in your middle initial name, which is the same style of name that your taxes will come in. and then they didn't put a driver's license number. So, but these were never returned, right? So we got warrants that were never returned. I didn't mean to have that person's name in there. Sorry, Lawrence. I guess not that big a deal. We're going to get you out of jail, right? So they mess with your name in all sorts of different ways, because when your name's in all caps, it isn't necessarily words. Those could be symbols that look like words when they all fit together. So, right? Another case of, hey, this name of this court isn't the same as the name of the state court, therefore this must be a improper venue. And they're simulating a legal process under color of law. Okay. Now, this one's a little bit different. Here last week I got a call because somebody came in the middle of the night and took a lady's car out of her driveway. Of course, it was some recovery service for somebody who said that it was their car, credit card company or whatever. And but so here is something you should do if you have car payments. Go get the title to your car, and it's going to have the name of somebody on there that's the first or the secured party or lien holder, whatever they want to call it, and look at the name and look at the address, and then look at the name and the address on the coupons that you're filling out to pay for it. It has a different address. Could be the same name, but it's using a different address. Well, it's a different place then. The lien holder is the lien holder, and his address is on the damn form, and that's where the payment should go. Well, that isn't where you're sending your payments. And so Betty wakes up the next morning. Her car is gone from her driveway. She calls the police to say her car's been stolen. And the police said, oh, we got a call from Michigan Recovery Services that they said they were going to come and take the car last night. And so Betty says, well, do you have a court order from them, or what do you have? Oh, no, we don't have anything like that. It was just a courtesy call. Right? So they don't have the police have no evidence that Michigan Recovery Service has any authority from anybody to take Betty's car out of her driveway, yet they did. So last week I said, well, let's write a letter to the chief judge. And and we'll file it as a motion. Order to show cause why these people shouldn't be held in contempt of court for taking your vehicle without having a court order. Something to that effect. I don't remember what the words were. And as it turned out, the chief judge on a particular day in Oakland County hears motions. And it can be motions that that have been scheduled to be heard, or it can be add-ons if there's time. So just go there. And when they have time, say you want to petition the court. For a motion to show cause, for basically a subpoena to have somebody come in and answer why they took your damn vehicle. Well, she got stopped at the door and got, what are you here for? Blah, 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 blah. And she got kind of turned around and they said, well, you can't do it that way. That's not the way it's done. You got to go over here. You got to open up a court case and so forth and so on. But look at what it says when you open the court case. It says State of Michigan on the top. In the circuit court for the county of Oakland. Well, right, we don't want the circuit court for the county of Oakland. We want the circuit court for the state of Michigan. So this is an improper venue. They take you and put you in an improper venue when you want to be the plaintiff. And I've mentioned this to, to Betty, and we're going to try to get it rectified, but with the thing that she put in, the interesting thing is they did put her in her proper name, proper case, and they put these people in their proper name, proper case. And then they pointed out the order denying the ex parte relief that we were looking for. And mainly, if you were to look at all these, it's because the affidavit wasn't done as an affidavit. We were hoping to do all that stuff at court. Right? If you want to take my oath, do it, because we wanted the affidavit. Because when they take you to this jurisdiction, they don't use notary publics. They use civil notaries. It's a different jurisdiction, right? It's not a common law jurisdiction. And a common law, a notary public is a common law officer. We need it to be in the other venue. This venue, it wouldn't do you any good. And so you would have to have like the court clerk render you an oath, or the judge, or something like that. But I just don't think you can use a notary public because it's the wrong venue. So we'll see where we do with this, but that was my point. I'm not really sure how to use it to prosecute with yet, but I know what I'm looking for based on what the law says, so let's take a look at that. Okay, so if you find in your legislature, wherever all your laws are stashed, right, they're all online someplace, and see if you can search on the word venue and just start to see what you come up with. So here's some of the things you do if you go to the Michigan legislative website and search on the word venue. Michigan Compiled Law 600.910, admission to bar, discipline, venue. The Supreme Court and each circuit court has jurisdiction to admit to the bar of this state persons who possess the required qualifications, to disbar or suspend members of the bar for misconduct, and to reinstate licenses to practice law. All such matters and proceedings are declared to be civil in nature, and the venue thereof is subject to the regulation by the Supreme Court. So that's the venue I want. I want the venue that's regulated by the Supreme Court. And so taking this law to the clerk and say, well, this is the venue I want. I don't care what you call it, right? Give me the paperwork that goes to this venue because this is the one I need to bring my civil in nature complaint to get a remedy. Now, some other things to do with venue. Open Meetings Act, decisions of a public body. Venue for an action under this section shall be in any county in which a local public body serves, or if the decision of a state public body is at issue, in Ingham County. So if you have a problem with a state officer in Michigan, then the proper venue is Ingham County. And you can see it's lowercase county. It's just Ingham County. Now look at this one. State Housing Development Authority. The venue of such action or proceeding shall be in the county of Ingham. Again, lowercase county, county of Ingham. Either way, it's Ingham. That's the proper name of the thing, and county is just a describer of it, right? It's the common word describing it, but I don't believe county of, lowercase, Ingham, and Ingham County, with county lowercase, are different. I think they're the same thing. What's different is when you start capitalizing the C on county, because Ingham County, with the C capitalized, is more like the political, the body corporate that was created as part of the politic body corporate for a county, defined territorial land called Ingham. Where if you capitalize C on county of Ingham, county of Ingham is like a entity trying to act like the government. I've been trying to find out who the county of Kent is because I got the Kent County. When I asked for W-9, it came in the name County of Kent. And there's no records with the IRS of anybody called the County of Kent. And when I FOIA'd to the Kent County FOIA for whatever records there are for the creation of the County of Kent, they emailed me back or FOIA'd me back, answered my FOIA saying no such records exist. I just haven't really known who to take it to yet. But I'm thinking now I need to go to Ingham County. I'll just say it's a state matter and file my action with Ingham County. Because the one that we're looking for, right, if I was to say, well, what venue are you looking for? It's the one for criminal. I'm trying to point out a crime. Right? Now, I know that they just said this is civil here with the attorney, but I'm going to say, well, it's the same venue anyways. The venue's the venue. It's the venue of the state. It's the one regulated by the Supreme Court. That's what I want because if, I don't agree with the judgment of the lower court, I want to take it to the Supreme Court. So it needs to be regulated by the Supreme Court. Need the venue regulated by the Supreme Court. And it reminds me with Billy in his traffic case, we wrote to the Supreme Court instead of writing to the chief judge of the circuit court or the county first. We tried writing to the chief justice of the Supreme Court, and it got intercepted by a clerk. In my last video, I was talking about this, and I'm actually showing the letter. But the clerk's pointed out that it looks like we have a problem with the 41st District Court, or whatever it was, some number, 41, or whatever the number is, not written out. Well, that isn't really true, although that's where the action is, right? Because it's in the wrong venue. That isn't a state court. The 41st District Court's not a state court. It's a court that's under King George III and his successors. And for whatever reason, that's where they take us when we try to open cases, and that's where they open up all their cases. And again, this is a traffic issue, right? And so the prosecutor of the county is using his public office for private gain because it's not being tried as a state matter, even though it's quoting state compiled laws that have been violated. Yeah. Now, there was just a few other things because this had to do with, where was it? Cases that having to do with venue. Okay, so the plaintiff is some leasing company and the defendant is some other company. And this is in the Michigan, or the state of Michigan Court of Appeals, in which this is a consolidated appeal from the trial court's issuance of orders granting plaintiff's motion for final judgment and plaintiff's third motion for partial judgment disposition. We affirm the defendant's first issue on appeal. Is this what I wanted? Okay. Pursuant to Michigan Court Rule 2.223, if venue in a civil action is improper, the trial court shall order a change of venue on timely motion of the defendant or on its own initiative. So that's why, well, you could write the judge and say, look, this is in the wrong frickin' venue, and the judge could go and put in the motion. He can change it. He can issue the order. When a challenge to venue has been raised by a defendant, the burden is on the plaintiff to establish that the county he chose is the proper venue. Right? So they're telling you if you bring it up, they have to decide. Plaintiff appeals as of right order dismissing the charge against the defendant on the basis of improper venue. We affirm. I believe that means they're affirming that the Grand Traverse Circuit Court was correct. Because the plaintiff complained about proper venue. Whether his reasons make any difference, it's the fact that he did. A trial court's determination requiring the existence of venue in a criminal prosecution is reviewed de novo from the beginning, like a brand new case. Venue is part of every criminal prosecution and must be proved by the prosecutor beyond a reasonable doubt. Due process requires that trial of criminal prosecution should be by a jury of the county or city where the offense was committed, except as otherwise provided by legislature. But in either case, the city or county is in the state. So really, it's the state. And then, what is the proper village, vicarage, whatever they called it, to draw the jury from? But first, it has to be in the state. The trial court properly granted defendant's motion to dismiss on the basis of improper venue. That's what the court said. U.S. court dismissed improper venue. For the reasons set forth below, the court grants defendant's motion. And what was the defendant's motion? Filed this action violated both the federal and Michigan statutes concerning collection of debt before the court is defendant's motion to dismiss for lack of personal jurisdiction and improper venue. All right, so that's what this is about, is the defendant has motion for dismissal for lack of personal jurisdiction and improper venue. The court grants defendant's motion. And so a lot of this had to do with personal jurisdiction, but the one I'm interested in is the part for improper venue. In a civil action, venue is proper in a judicial district where any defendant resides. So where does the defendant reside? He resides in the state. If all defendants are residents of the state in which the district is located. Right? So if it's in the state, then it's a county. It's not a district, it's county. A substantial part of the events or omissions arriving, blah, blah, blah. If there is no district, the action may otherwise be brought, yada, 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 rah, rah, rah. The court may examine facts outside the complaint. Under the venue statute, a corporation is deemed to reside someplace. Okay, so the court's not persuaded by the plaintiff's argument, right? So the plaintiff must have come back and argues that the statute allows for the suit in any district court. But that's the problem. It needs to be in a state court because the defendants are in the state. If they are in the state. I guess my point is, hey, they do dismiss cases when people bring up the fact that it's an improper venue. So let's just start there and see what they say. That's what I wanted to point out. All that to say that. Then I'm going to go try to help Sam a little bit more. So Sam Girod has an attorney called Michael B. Fox. If you were one of the people following this thing with Sam, that's his attorney. This is the man that could undo his damage by putting in a motion for Sam. But Sam could put it in, and if you know anybody already incarcerated, they could appeal because it was in an improper venue. And it's a violation of the constitutional rights, or rights protected by the Constitution. I'm talking about people like Tim Turner, been put in jail for God knows how long, 161 years for IRS bullshit, in a court that doesn't have the jurisdiction to charge him. Or who's the brother in Utah that does the bond stuff? I just can't remember his name. I got his picture or his head face in my mind. I can't think of his name. He just got popped too, and they want to put him in prison for 60 some years or something. I just can't think what his name is. Right? But if you're people that follow this kind of stuff, you know what I'm talking about. There's all sorts of people going to jail because they're going to an improper venue, being taken there by officers of the court who, because they have done that, are in contempt of court. And so if you do nothing else other than donate, if you please can, hey, PayPal, Western Union, mail, put in something that says, I, in your full legal name, petition the court ex parte to issue an order dismissing this matter due to the plaintiff's attorney of record prosecuting in an improper venue, and award me reasonable attorney fees and other equitable relief the court deems just, and to set me free, free about my business, add whatever you want. But, if you're the defendant in any kind of case in America right now, you're the defendant in a jurisdiction or venue beyond the sea, whether it's at the state or federal level, you're being taken out of your venue and put into a foreign venue. And unless you complain, petition, make noise about it, they're going to assume you're okay with the venue, and in the venue they put you in, it's Talmudic law, and they can do to you as they please. You have no reason to complain. You want to complain about the venue first, and see where it goes from there. Okay, that's what I had for you, and I really do. If you can, I appreciate your help. Please donate. Have a great day. We'll see you.